So our speaker today, he's been in business for 44 years. He has done over 200,000 evictions, if you can believe it. And he has ramped up, like he's increased the number of attorneys that he has working with him right now. He's up to 19 or 20 of them. So I know that it's been busy and he's really increased there. And even us, we've had to add people to our staff as well to deal with the increases here. And anyway, he is here to bring you, and he's the CEO founder of his law firm. And so it is my pleasure to introduce to you today, Dennis Block.
Thank you, Jeff, and welcome everybody. Appreciate everyone coming out to hear this great webinar. We have to appreciate the Apartment Owners Association, which is always trying to educate their members and landowners in our state of California. As Jeff said, I have been doing this now for 45 years of representing income property owners. We have seen about everything that you can possibly imagine in that time period. Governmental regulations that always are trying to impede the progress of landowners. But quite frankly, ladies and gentlemen, I've never seen anything like what's coming out now. The regulations that are affecting income property owners in the state of California are tantamount to a government taking. They are attempting to remove any rights that we have as landlords. I'm going to be going into the so-called Tenant Relief Act. But if you think about the Tenant Relief Act, it literally prevents landlords from contractually obtaining their rent for 17 months. 17 months, ladies and gentlemen. Right now, it's extended from March of 2020 through the end of June 2021. How many people could be in business where they give up their goods and services and do not get paid for 17 months? They're literally trying to throw our industry into the ocean and drown it. And that's where we're facing right now, this moment. AB 3088, the Tenant Relief Act, should really be called the governmental assault on income property owners. That's exactly what it is. They are forcing you to give your services, and with absolutely no hope that you will ever get paid. The statute goes on to talk about that this is merely deferred rent, that we're deferring rent where tenants will have to pay you. The truth of the matter is it's not deferred. It's where you are going to literally be losing that rent potentially up to 17 months. I'm going to go over the so-called Tenant Relief Act and how it was extended in a statute called SB 91. I'm going to talk a little bit about statewide rent control and ways to get around it. I'm happy to tell you. We're going to talk about, what's going to happen when this statute is over come July 1st, because that's just around the corner. And also some of the requirements that are required under statewide rent control that you must follow. That this will be a potential defense in an eviction case if you don't follow these simple rules. So let's go over the statute, AB 3088, and how it was extended with SB 91. Also, I'm going to be going over the Tenant Rental Assistance Program, which will allow owners potentially, and I use that word with emphasis, potentially to receive 80% of lost rent if in fact the landlord is willing to give up 20%. Okay, so let's start in the Tenant Relief Act, they talk about 2 periods in time. The first period, it extends from March 1st, 2020 through August 2020. So for that time period, that is called the protected time period. If a tenant owes rent during that time period, you are required to serve a 15-day notice to pay rent or quit. That notice has to be accompanied with an information sheet as to the parameters of this, quote, protected time period. You have to also include a declaration that the tenant would need to sign and send back to you. And also you have to give them the actual law of AB 3088, a copy of that law. Assuming you serve all those notices on your tenant for rent owed, once again, from March 2020 through June 2020, the tenant will have 15 days to do something. Well, the 15 days would either be to pay you all the rent they owe for that time period, or return the declaration to you within the 15 days. If the tenant returns that declaration to you within the 15 days, he has now complied with that 15-day notice for this protected time period. And in fact, by returning that declaration to you, the tenant actually doesn't owe any rent whatsoever, because under the guidelines of this statute, that is now not considered rent. It's considered a civil debt that's owed to the landlord. Well, what's the difference, you might ask, between rent and a civil debt? They both owe it to me, and it's both the same amount of money. But the truth is, you can't evict for a civil debt. You can evict for something called rent. So if, in fact, the legislators, by AB 38, has now transmuted rent into something different, that is a civil debt, then that means by just merely returning that declaration, you have no basis of ever bringing forth an unlawful detainer, an eviction lawsuit, to evict that tenant and get a judgment for what's owed to you. So what can you do now that it's a civil debt? Well, under the statute, you can bring forth a regular civil lawsuit, where you would hire a law group such as mine, or you could even go to small claims court and sue for that. Now, small claims court, based on the statute, its jurisdictional limit used to be $10,000. It is now raised to an unlimited amount for this type of rent that's owed for this, quote, protected time period. Once again, from March 2020 through August 2020. So small claims court is now unlimited. Now, you can't bring forth that small claims court action until August 1st, 2021. August 1st, 2021, any rent owed during that protected time period where the tenant returned the declaration to you, you can then bring forth a small claims court action. Our firm is actually going to be assisting landlords in preparing all the documents and attempting to locate your tenant to serve them. But that's when you can bring forth this action. Technically, that money will be due on July 1st, 2021, but you won't be able to bring forth a lawsuit until August of 2021. Now, if you think about this logically, where the legislators in AB 3088 said, this is just deferred rent, ladies and gentlemen, just deferred. We're not telling you that you have to give it up. We're just telling you that it's deferred. It's deferred now as a civil debt, and you can sue for it on August 1st. But what happens if your tenant leaves? So you go down to the small claims court on August 1st and you file your own paperwork. But the next thing you'd have to do with a small claims court action, you'd have to serve your tenant. How are you going to serve him if you don't know where the tenant moved to? Or maybe he went to another state. And he certainly is not going to give you his forwarding address. And you only have 1 year to bring forth this action. Otherwise, it's considered waived by statute of limitation. So in effect, while the state legislators and our wonderful governor indicated that we're just deferring rent. The truth was they're forcing landlords to give up potentially all that rent for that protected time period. And once again, March through August of 2021. Now, there's another time period that we have to consider, and that's the transition time period. The transition time period goes from September 2020, and now that's been extended through June 2021. So if you add the protected time period to the transition time period, literally you have landlords that will go out without rent for 17 months. Oh, and by the way, during that 17-month period, do the landlords have to pay their mortgage? Do the landlords have to pay property taxes? Do the landlords have to maintain the utilities, water and sewage for the building? And last but not least, when that pesky tenant who hasn't paid rent in 17 months tells you that his garbage disposal has broken, do you have an obligation, a legal obligation to fix it? And the answer is yes, you do. So all this money is coming out, and literally no money is coming in. Once again, this is a governmental assault on income property owners that no one could possibly even dream up except for our wonderful California state legislators and that pesky governor Newsom. By the way, everybody sign your recall petitions if you can immediately. Okay, let's continue with the transition time period. The transition time period, again, it goes from September 2020 through June 2021. For that period of time, if a tenant owes rent, you again have to serve a separate 15-day notice, a separate information sheet which explains the transition period. You also have to include that declaration so the tenant can merely just sign it and return it to you. And also you have to give a copy of the AB 38 law, the Tenant Relief Act. Now, within that 15-day period for the transition time period, if the tenant returns the rent to you in full, that's great. But otherwise, if he returns the declaration to you, then that's, again, is going to be considered a civil debt, but just for 75%. 25% for the transition time period is actually still considered rent, and he has to pay it to you. Well, when does he have to pay it to you? Well, you're serving a 15-day notice to pay rent or quit. And at the very minimum, if he returns that declaration, only 25% is owed. So if a tenant owes you $2,000 a month rent and he doesn't pay for 2 months, that would be $4,000. 25% of that would be $1,000. So logic would tell you that the $1,000 would at least have to be paid during that 15-day period. But that would be logical. And there's nothing about this law that's logical. So the 25% has to be paid by June 30th, 2021. June 30th by 2021. Again, that's from all the rent owed from from September 2020 through the end of June of 2021. Now, if the tenant doesn't pay that rent, the 25%, you can immediately bring forth an eviction based on that 15-day notice. Okay. Now, one might ask, what happens to the 75%? Is that just thrown out the window? Well, the truth is it's just like the protected time period. 75% is considered a civil debt. You can't ever try to evict for that 75% because it's not considered rent. It's considered a civil debt. And you can bring forth, just like with the protected time period, you can bring forth a regular civil lawsuit come August 1st of the year 2021. If you go to small claims court, it's going to be unlimited. And once again, if you contact our office in June, or July, we're going to have a program set up to assist landlords to file and locate tenants for small claims court action. Many landlords are certainly capable of doing it themselves, but our firm will be offering that to you. So that's the difference between the protected time period versus the transition time period. Protected time period, it's all considered a civil debt. Transition time period, only 25% is considered rent due to you on July 1st. If not, you can bring forth an eviction action. Otherwise, it's all considered civil debt, and you can bring forth a civil lawsuit on August 1st of that time period. What happens on July 1st when this Tenant Relief Act is over? Well, unfortunately, ladies and gentlemen, I've heard that our legislators are considering extending it. And they're considering extending it to September 30th. So let's just ratchet up the amount of theft that's going to befall landlords. We're up to 17 months now. If they do extend it to September, that would be 19 months where you couldn't collect a dime from your tenant, and yet he's still inside your unit using utilities that you have to pay for. And of course, you're required to make your mortgage payments and your property taxes, etc. But assuming the legislators come to their senses and do not extend it, on July 1st, the tenant will owe you July's rent. And you can serve a standard 3-day notice at that time, a standard 3-day notice at that time to commence an eviction. So I would imagine that if this is not lifted, that at that time we'd be able to go forward with standard eviction cases. Okay. Also, of course, if they don't pay the 25% during the transition period, then you would be able to again bring forth an eviction come July 1st. Okay. Now, we have part of the SB 91 that extended the Tenant Relief Act until June 30th. It was supposed to be over as of February 1, but this extended it until June 30th. Now, they did add in one potential benefit to landlord, and that is under the rent relief program. There's a website that landlords can go to, which is called housingiskey.com. Housing, HOUSINGIS for is key, KEY.com. This is a federal program. I like to say another federal giveaway so that our grandchildren will still be paying for this debt. But it's a $2.6 billion federal giveaway, which will be made available or is being made available to landlords and tenants in the state of California. It operates to pay landlords 80% of the rent owed if the landlord is willing to give up 20% of the rent. The period that this is for extends from April 1st, 2020 through March 2021. That's a 1-year period, okay? We understand that AB 3088 extends through June, but for the rent relief program, landlords and tenants can apply at housingiskey.com, and as long as the landlord is willing to give away 20%, then for that 1-year period, potentially, and I use the word potentially, they can get 80% of the rent. Do I recommend landlords doing this? And the answer is hell yes, because the chances of you collecting the quote civil debt from your tenant is probably going to be in the neighborhood of maybe 15% of landlords will be able to collect, in my opinion. Even if you do bring forth a small claims court action and get yourself a judgment, the question would be, how do you collect on that judgment? Does your tenant have any money? Do you know where he works to garnish wages? Do you know where a bank account is? So if landlords have the ability and the right to collect 80% of the rent, I wholeheartedly recommend that you take that route. Give up 20% of the rent to get rent for that 1 year period. Once again, it's from April 2020 through March of 2021. But there are some requirements. So what are the requirements? Number one, both the landlord and the tenant have to apply. If the landlord applies, then an invitation is going to be sent out to the tenant. It's going to be sent out 3 times. If your tenant doesn't comply, then you are not eligible for any rent assistance, Mr. or Mrs. Landlord. Now, why wouldn't a tenant want to comply? Let's think this out logically. If the landlord's going to give up 20% and the state's going to give them through the federal grant 80%, then that means for that 1 year period, your tenant just got free rent for a whole year. Now, I don't understand what would be flowing through the brain of a tenant for not complying when they'll have no rent obligation for a whole 1 year period. But we've seen in so many cases, my clients have applied and the tenants, for whatever reason, haven't. And this is anecdotal, of course. I have not had one landlord receive 1 penny of rent relief assistance. Not one. So, but again, certainly put yourself out there. I would certainly apply for that. What are the requirements? The tenants must have at least one person in the household who has lost their job or income during the pandemic, and here's the kicker, and can show that there is a risk of homelessness. Well, that's pretty grandiose, that not only did I lose some of my income, but I have to show that I have a risk of being homeless. I don't know how many tenants are really going to qualify for that, and maybe that's the reason why they're not also applying when invited by the state program. The program extends, and of course, you guys will all believe this, you don't have to be a citizen. A tenant doesn't have to be a citizen. He can be an undocumented alien, and he still qualifies for this. If the tenant applies, then the state will then invite the landlord to apply. I don't know how many cases that's happened, but certainly I would encourage landlords out there to apply to this program. By applying to this program, you have at least a chance of getting 80%. Do it now before this money runs out. Though again, I'm not seeing how many people are actually going to do this, but definitely fill out those forms. Go to that website, housingiskey.com. And if that is the case, if you can get your money, then it's worth it to give up 20% for that 1 year period of time. With regard to rent owed from February and March of 2020, and also rent owed from April 2021 through June of 2021, that's fair game. Either it's going to be considered a civil debt and you'd have to sue separately for that, or 25% of the rent would be owed for that transition time period, and then you could again bring forth an unlawful detainer on that. And once again, assuming this is over, you have the right to commence with a regular 3-day notice for rent come July 1st of the year 2021. So coming up in about, a couple of months from today. During this time, evictions are not banned. Everybody thinks they are. You can certainly go forward with an eviction based on certain criteria. Obviously, I've told you the criteria for rent, but there are other criteria upon which landlords can immediately bring forth an eviction, which of course my firm is doing. And those include breaches of the rental agreement. That is, for example, where you have unauthorized occupants in possession. We would serve a 3-day notice to perform or quit, and if the tenant did not remove the unauthorized persons, we have the right to go forward. We've also have brought forth cases dealing with unauthorized pets on the property. The rental agreement prohibits dogs. They bring a dog or a cat onto the property. We've brought forth cases where there's alterations to the premises. Somebody puts up a satellite dish, or they build a shed in the back. All kinds of crazy things we've seen. In those kinds of cases, nothing under any of the laws that I've just talked about prevents us from bringing forth an eviction. We have been doing, with some success, evictions based on the fact that the tenancy has terminated, the lease has terminated, and the tenant didn't vacate at the end of the lease period. We've had some mixed results on that, but we had many evictions that have gone through on that. We've also seen another disturbing scenario, and that is that you have a specific tenant, we'll call him Tenant A, who is your tenant. Maybe he's paying rent, maybe he's not. In most situations, not. And then Tenant A decides to move. Maybe he's even given you a 30-day notice, and at the end of the 30 days, hands you the keys, shakes your hand, and is happily on his way out of the unit. But as the landlord attempts to take possession, he realizes that Tenant A left strangers behind. This is happening so many times. Of course, Tenant A thinks he's off the hook on the basis that, hey, I gave you the keys. I don't know who these people are. But of course, he brought them in, or she brought them in. So that's a type of an eviction that we can immediately bring forth to either evict the strangers directly or to bring forth an unauthorized person type of eviction against your tenant who's left. Your tenant who's left is physically not occupying the property. We understand that. But your tenant who has left is legally still occupying the property, because in order to physically vacate, you have to take yourself and all of your strangers with you. If you leave people behind, that means you are still legally occupying the property, even though physically you're not there. And that tenant could be the subject of an unlawful attainder that we could bring forth right now. Okay, so those are the types of cases that we are bringing forth right now. If you don't want to wait for July to start potentially bringing forth cases, and your tenant has violated the terms of a written contract, then in that situation we can commence those cases right now. So be on the lookout for those types of scenarios. Okay. Under statewide rent control, there are some new requirements that landlords have to follow. We are already getting pushback in cases that we are bringing forth in the eviction court because the landlord hasn't complied with AB 1482 statewide rent control. Now, I want to emphasize that you do not have to comply with what I'm about to talk about if your property is subject to a local rent control ordinance. So if your property is subject to the San Francisco rent control, or your property is subject to Los Angeles or Santa Monica, any local jurisdiction which has its own rent control and your property is subject to that rent control, you don't have to follow this. But for example, if you have a single family home in the city of Los Angeles, that wouldn't be subject to Los Angeles rent control. So now we have to consider, what do we need to do with regard to complying with AB 1482 statewide rent control? So, if there's two criteria, if your property is not subject to any rent control, your property is not subject to any rent control at all, then you must serve on existing tenants a notice to that effect. Now, this is part of the AOA website. Please get that form and serve it on any existing tenant. So if you've got those single-family homes out there, it's not subject to anything, then please serve this notice on all of your tenants. If you have a new tenant coming in, then this is an integral part of your rental agreement. So anybody renting out a single-family home has to have a phrase in that contract, or a townhouse or a condominium, that is not subject to any rent control. So this is for new tenancies. You have to have this phrase in your rental agreement, or you're not in compliance with AB 1482. Now, what does it mean not to be in compliance? Well, if you don't tell your tenant that he's not subject to statewide rent control, then courts are interpreting that to indicate that you are now subject to statewide rent control. So here you had a single family home, you had no rent limitations, you could evict the tenant for any reason whatsoever. Now all of a sudden, because you didn't comply with this law, your property is now pushed into statewide rent control. So for existing tenants, just serve this notice to your tenant that, hey, your property is not subject to AB 1482. You're not under any rent control. Or for any new tenancy created, make sure that is contained in your rental agreement or an addendum to your rental agreement that, in fact, you are not subject to rent control. Now, if your property is subject to AB 1482, that means it's not subject to a local rent control statute. Then in that situation, you need to, again, serve a notice on existing tenants that, by the way, Mr. Tenant, Mrs. Tenant, you are subject to statewide rent control. And if you're renting out a property, which would be subject to statewide rent control, you have to have that phrase in your rental agreement, specific language that must go into that rental agreement. Again, you can get this under wonderful AOA website under their free forms. I encourage you to join this if you're not, because they have valuable information and all their forms are unbelievable. And I know they're unbelievable because, quite frankly, I helped write them. So definitely make sure that you comply with the AB 1482. Now, a lot of landlords got stuck when AB 1482, the statewide rent control, was instituted. You know, they lived on a philosophy that, I don't need to have my rents up to market value. My property's not under rent control. If I ever want to raise the rent, I can certainly do that. Maybe when I get older and I'm going to pass this property along to my kids, maybe I'll do it then. But then, lo and behold, AB 1482, statewide rent control, reared its ugly head. And you've got that beautiful ocean view apartment in Redondo Beach, or some beach community, that this 2-bedroom apartment was only going for $642. And now statewide rent control came in. Currently for that area, it's 5% plus the CPI. So you'd be able to raise that rent a whopping $75. And you can imagine the disdain of your children when you pass this unit to them. Like, what'd you do to me, Dad? $642. I don't even want this building at this point. The property taxes are more and my upkeep on this building is more. So what do you do in that situation? Well, you can't do anything right now, ladies and gentlemen, but come July 1st, when this Tenant Relief Act is over, hopefully July 1st, there is an escape valve that anybody can take care of. So this is for those landlords out there where you want to raise rents and your rents are way below market value. Now, if your rents are reasonable and the CPI, every year you're allowed to raise it plus 5%, and if that's fine for you, then that's great. But there is a way around this for rents that are seriously under rent control. And I can just hear all the phone calls coming to my office. Remember, this is for properties subject to statewide rent control, not the Los Angeles rent control ordinance, not San Francisco rent control ordinance or Santa Monica. If your property is subject to statewide rent control and you're suffering because you were not the best of landlords and didn't make your rents market value, there is this escape valve. The escape valve is that you are allowed to evict a tenant if you're going to renovate the unit. Now, I would submit to you that if you're renting out a unit for $642, when that tenant leaves, you're going to want to get maximum rent. So you're going to want to renovate the unit no matter what. So the terms for asking a tenant to move require that the work is going to take 30 days. Well, everything takes 30 days. It's going to require a building permit, either an electrical or a plumbing permit. But again, if you're going to remodel the kitchen, if you're going to remodel the bathroom, then in that situation, you're going to need a permit anyway, and it's going to take longer than 30 days. That's going to be, you'll be qualifying for substantial renovation. In that situation, you would serve that tenant a 60-day notice to vacate, and you have to pay that tenant relocation money. Well, what's the relocation money? The relocation money, ladies and gentlemen, is only 1 month's rent. So basically, when July 1st comes, if you are subject to statewide rent control and your rent is way below market value, we can serve for you, or you can do this yourself, a 60-day notice to vacate based on renovation. We'll offer the tenant 1 month's rent, which would be a credit towards the last month of his tenancy, so you don't even have to actually pay him anything. And then once that tenant leaves, you are duty bound to do that renovation. Make sure that it does require a building permit, because these tenants will come back and you don't want to find yourself in an eviction in a civil lawsuit for wrongful eviction. So do the work, get the building permit, and then for the next tenant coming in, you can raise the rent to market value. So under statewide rent control, we really do have an easy path of getting around it so that your apartments are all at market value, which is what all landlords should be doing. Otherwise, I believe the AOA has a broker service, and you should be selling your building. Otherwise, act like a businessman and make sure that you are getting market rents for your property. If your property, and the last thing I'm going to talk about, if your property is not subject to any rent control and you want to raise rents, there's a relatively new law that came into existence about a year ago that states if you're going to raise the rent 10% or less, you need to serve a 30-day notice to increase the rent. If your property is not subject to any rent control and you want to raise the rent in excess of 10%, then you need to serve a 90-day notice. There is no 60-day notices anymore. So 10% or less is a 30-day notice. In excess of 10%, it is a 90-day notice. Now, if you're in a situation where a tenant is claiming COVID as to the reason why, and he's returned the declaration, and we're still in this period right now, because it's not July 1st yet, so we're still under this AB 3088, the Tenant Relief Act, I'd like to tell everybody that there's nothing in the law that stops us from raising rents right now, this second, either pursuant to the statewide rent control, which is 5% plus the CPI, or if you're not subject to rent control, you can raise the rent to whatever you like, a 90-day notice. Now, the tenant might not pay you because he's claiming the COVID card, as I like to talk about it, but at least the rent will be established. And you can do that right now, ladies and gentlemen, and raise these rents for properties that are not subject to rent control, or even if it is subject to statewide rent control, please raise the rents right now. Nothing in the law prevents us from doing so. I can tell you as I end this that the amount of tenants that are playing the COVID card is astronomical, where tenants are going to work every single day, and they're just merely using this pandemic as an excuse for not paying rent, and literally now 17 months of withholding rent for their landlord, even though they're going to work every day. We see this in cases where the tenant is on a pension, never worked, and yet they're claiming that they're affected by the pandemic. If you think about it, the latest Bureau of Labor Statistics states that there's only 6% unemployment. That was the latest one that just came back. So you know what that means, ladies and gentlemen? That means 94% of the people are working in this country. And if 94% of the people are working in this country, how come we have so many tenants claiming they can't pay rent, even current rent? Okay, maybe you lost your job, but you're working now. So we're seeing case after case after case of an abuse of this system. Our politicians need to step up to the plate, end this thing on July 1st, or really risk the wrath of income property owners and anybody with a fair sense of play that this is not the way society can be. We have certain lawsuits that have already been filed because this is clearly a taking. Those lawsuits are slow, but are going through the federal court system, and hopefully it'll come out on the right side for landlords for this state, which literally has stolen our money, which is exactly what has occurred. I'm going to open it up now for questions. I do have an 800 number. I don't know if it was on the screen. It's 1-800-77-EVICT if you do have any other questions. I also have a website, which is evict123.com. And Jeff, I think, are you ready to feed me some questions? Now take it easy on me, guys, because I've been standing here for a long time, but I'm happy to answer them.
All right, we're going to open up for questions, but before we do, I just want to bring it to your attention that we do have a new service for you. There's a coupon page, so if you're needing any kind of service, you can go to our website, and I think you'll see it on the screen right now. You can go to the website. If you click on that coupon page, you'll be able to get discounts on lots of different things, so you'll want to check that out. And also one other thing, just real quick, and I mentioned this, these are just two things that are new, and I just want to make sure everybody heard about them. But we have the document screening program, and there has been some confusion, and so I want to just explain that one more time. And basically what happens when you're taking applicants and you want to verify their pay stubs and their bank statements, we do have a service that can do that for you in the member portal. And so, but what you need to communicate to those applicants is that they need to directly download their bank statement from online and then save it as a PDF. And then the same thing goes for the pay stub, that they get that they download it online and then they give you that PDF. So don't take a picture, don't take a screenshot, don't take a printout, but take those. If you have those, the two most recent of each of those items, you can upload that into our system, and there's an AI-assisted technology, and that there's a company that is providing that. It's called Snapped, and there's an article even in the magazine about it. There's been multiple articles, but anyway, what that service will do, it will screen. It'll look at those and tell you if anything's been manipulated. Photoshop's out there. They Photoshop the bank statements. There's a pay stub creator that you can get for $8.95 online. So you just want to make sure that people are telling you the truth, because they say that 50% of evictions happen. It starts with that fraud in the application process. So you want to catch it with the tenant screening, but also with the document screening, just to make sure you have everything. So thank you for bearing with us on that. Remember, AOA membership, if it's your first time, it's 100% money back guarantee on it. So we just want to encourage you to join. But now we'll get to the questions. So thank you for your patience. Here we go. All right. Okay. Glad on YouTube. Tenant has not paid rent since last February 2020. Starting in March 2020, no rent was received. When can I take action?
As I was stating, with regard to the transition time period versus the protected time period, you should be serving 2 15-day notices at this time, one for each of those periods, included with the declaration and the other forms. And if you do that, then come June 30th, the tenant will owe 25% of the rent owed from the transition time period. So if that's the case, serve that notice now, and then we'll be able to proceed forward come that date. We're hoping, of course, that the legislators do not extend this beyond June 30th.
All right, here's one from Michael. Can we raise rent for Section 8 tenants? They reside in the condominium.
Well, a tenant who's in a condominium, you always are allowed to raise rent. There is no limitation for condominiums, houses, or townhomes. But the problem is that you've agreed to join the Section 8 program where rent is subsidized by the federal government. In that situation, you can only get a rent increase with the approval of your Section 8 advisor. So even though you have the right to raise rent under general state law, you've signed a contract with the federal government and either a local municipality or the county. And because of that signature, you have to wait for them to approve any rent increases.
Great. Okay, on YouTube, MGV videos. Can we evict tenant if tenant doesn't return any signed declaration of COVID-19 related financial distress form for January, February, March of 2021?
I'm glad you asked that question because I don't think I gave a clear response during my talk to you. But if the tenant doesn't pay the rent in full or doesn't return the declaration, then you can immediately bring forth an unlawful detainer at this time. We've done many of those types of lawsuits as well. So again, you serve the notice, you wait 15 days. And by the way, when we talk about 15 days, you would think just take out a calendar and start counting days, but that pesky legislators have a different way of counting. You have to exclude Saturdays, Sundays, and legal holidays. So really a 15-day notice, Jeff, is about, 22 days at the minimum. So make sure you count it directly. And if in fact the tenant doesn't return the declaration or pay the rent in full, then you have the right to bring forth an eviction at this time.
Great. Here's Virginia on YouTube. Thanks for the question. The tenants moved out in February with no address, owing $13,000 in rents. One tenant is an undocumented and has a fake social security number. Can I send collection letter to the working tenant's employer?
Well, I wouldn't send anything to the employer. You can certainly send it to your tenant and make a demand for the rent. If the tenant never sent you the declaration, you could sue for it right now. Unfortunately, if you do it in small claims court, you're limited to $10,000. If you wait until August 1, which I would recommend, then you can sue unlimitedly. It's actually really good that you know where your tenant is working for two reasons. Number one, you have an easy way to serve them. So you can have your process server or the sheriff go over to that place of employment and serve them there. The other reason why it's great that you know where the tenant works is that once you obtain a judgment, then you'll be able to garnish his wages, which is a procedure once you get the judgment that you can set up. So you actually will know how to serve them and where to serve them and also how you can collect on the judgment. So make sure you always know where your tenants are working and where they bank, ladies and gentlemen, because it does help when your tenant vacates. Obviously, my firm does collections, and we have ways of skip tracing where we can find out where they work and where they're currently living and bank accounts. I mean, we're not 100% successful, but we're pretty good at finding that because we do collect on a lot of debt, on a lot of old judgments.
Great. Here we go. Hermosa property. Can we raise rents in Hermosa Beach now? And how about the city of LA?
In the city of LA, I like to call him King Garcetti, you might know him as Mayor Garcetti, has stated that there can be no rent increases of any kind for rent control property in the city of Los Angeles. So if you're under RSO, you cannot serve any rent increase until such time as the king declares that the emergency period is over. Once the king declares that the emergency period is over, then you can raise rent in 1 year. 1 year later, you can raise rent. Now, for the other municipality, did you say Redondo Beach or Hermosa?
Hermosa, yeah.
Hermosa Beach? Okay, so Hermosa Beach and also Redondo Beach doesn't have a local rent control. So if it's like a single family home or a townhouse or new construction built within the last 15 years, you're not subject to any rent control. So you can raise the rent as much as you like. Again, if you go above 10%, you're going to need to serve a 90-day notice. But if you have an apartment house in Hermosa Beach that was built over 15 years ago, you are now subject to AB 1482, statewide rent control. And by being subject to statewide rent control, you can raise the rent. Right now, it's 5% plus the CPI. For that area, the CPI is 0.7%. So you would be entitled to, at this minute in time, a 5.7% rent increase on those tenants. You can do that right now, notwithstanding the pandemic, or whether the tenant's paying you or not paying you, you still have the right to raise the rent.
All right, here we have one on Facebook. Debbie, thanks for your question. If a tenant refuses to apply for tenant relief or applies and doesn't qualify, is that grounds for eviction?
No, it's not grounds for eviction. Grounds for eviction are based on whether the tenant has returned the declaration and then whether 25% was paid during that transition period only.
Great. And here on YouTube, Fernando, when can I do an owner move-in into one of my units?
Actually, if your property is not subject to rent control at all, you can do that at this point in time. You need to serve on your tenant, if they've been there longer than 1 year, a 60-day notice. You have to inform your tenant that you intend to move in. If your property is subject to statewide rent control, you'd have to pay relocation money, which is equal to 1 month's rent. If your property is not subject to any rent control, then you would just serve them a notice, the 60-day notice, stating the reason, but no relocation money has to be paid. There is an exception, since a lot of viewers are in the Los Angeles area. Under the city of Los Angeles, you can, because of our King Garcetti, you cannot ask a tenant to move where there's no fault involved. So in other words, if you're asking a tenant to move because you or your family member want to move in, the tenant hasn't done anything wrong. So until the mayor ends the eviction moratorium for the city of Los Angeles, even if you want to move in, you can't do so. I have a lot of clients who want to serve notices on tenants because they're selling the property and I have to market it. Well, in the city of Los Angeles, you can't do that. If your property is not in the city of Los Angeles, for most places, including if you're subject to statewide rent control, if it's a single family residence, so therefore, you're not subject to statewide rent control, you can serve a 60-day notice right now for the tenant to vacate. That is permissible now under the law. You're not allowed to get a judgment prior to July 1, but by serving a 60-day notice now, you can't get an unlawful detainer judgment by that time anyway, so you're safe. So any property not subject to statewide rent control and you just want the tenant to move, maybe you want to sell the house, maybe you have other plans for the house, etc., you can certainly serve that notice.
Great. On YouTube, we have Joe. If someone serves a 15-day notice and the tenant does not return the declaration of COVID-19, that tenant may deliver the notice in court and the eviction could be denied. Is that still the case now?
That is still the case, but it needs clarification. So the law is so in favor of tenants' rights that the tenant has 15 days to sign his name to a declaration that you served on him. How difficult is that? If the tenant doesn't do it, you can bring forth an unlawful detainer action. But the law goes on to state that if after you serve the lawsuit on your tenant, the eviction lawsuit called an unlawful detainer, within the time that the tenant has to answer, if he files that declaration with the court, then the court is duty bound to set up a hearing. The hearing is to determine whether in fact there was excusable neglect as to the reason why the tenant didn't return the declaration to you within the 15 days. If the judge finds that there was an excuse on the part of the tenant, he didn't understand, he was sick, something to that effect, then technically the court will order that the eviction properly brought is now dismissed. We've gone on a few of these hearings, actually many of these hearings, and I can tell you that we've been very successful in that the courts haven't considered that this was excusable neglect, and the lawsuits have been allowed to go forward. So we're happy about that. But there is a possibility that after you file an eviction based on the fact that the tenant did nothing, that your case could be dismissed.
Okay, great. And what percentage, I'm just curious, what percentage of those are being judged in your favor?
I would say about 75%
Okay.
have gone through. So we've been very successful on those.
Great. And here's from the chat on the website. Victoria, Tenant A and Tenant B share a garage. Tenant A stores items on his side, which blocks Tenant B from being able to open his car door. Landlord is currently in the process of widening the garage door opening to even out the space for Tenant B. Tenant B has already filed a complaint to the DA's office claiming the landlord has not done anything to resolve the issue. Would this constitute negligence because the landlord has failed to resolve the conflict to date?
Well, I mean, obviously the landlord has to take responsibility. He's leased out 2 units with garages, and both tenants equally have the right to use that garage. If one tenant is encroaching on the space of another, then an action should be brought against that tenant, maybe even an eviction case. A lot of times rental agreements will state that you're not allowed to store objects. I know the wonderful AOA rental agreement, one of the best rental agreements on the planet, specifically states that a garage is only to be used for the parking of a passenger automobile. So in that situation, you could serve a 3-day notice to that tenant to remove all that personal property. And if he doesn't, then you have the right to bring forth an eviction. In addition, even if that's not contained in your rental agreement, it still would be considered of some nuisance value that he's encroaching upon another tenant's ability to park his own car. So again, another eviction action could be brought against the offending tenant.
There we go. All right, on YouTube, Jof, when will eviction court reconvene? I had a tenant who stopped paying rent 8 months before COVID.
Well, unfortunately, if the tenant stopped paying rent 8 months before COVID, and that would be something prior to March 1st, 2020, you can't sue for that in an unlawful detainer action ever, and it has nothing to do with the current law. It has to do with a general law on evictions, which state that the subject of an eviction cannot be for rent owed over 1 year ago. So, for example, right now we are in the month of April. So I can go back to May of 2020 through April of 2021. That's 1 year. But I can't go back any for an eviction and start it right now for any rent owed prior to May of 2020. So you're out of luck on that situation. You'd only be able to bring forth an eviction, bring forth a civil action. You can do that civil action now because you're talking about rent owed prior to March 1, so it doesn't really apply to the current Tenant Relief Act.
Great. YouTube, we have Janice. Can California continue to extend rent relief indefinitely?
Yes, of course they can. They could do it until everybody's bankrupt and everybody's lost their property through foreclosure. We're hoping that someone has a vision of the concept of economics, and that you can't just foist the financial impact of the pandemic on one segment of society, that segment being income property owners. And while I think it's dubious that these tenants claim that they're not paying rent because of the pandemic, and in my belief, I would say at least 75% are gaming the system. At least 75% are
Wow.
gaming the system. But at the very minimum, where is it in our land of laws, that it's been adjudged that one segment of society, that would be income property owners, has to now support people affected by the pandemic? Is there any other industry that has been told that we have to support another segment of society that has been affected by the pandemic? And the answer is no. And that's why these laws are all unconstitutional. Can it go on for forever? Yeah, it'll go on for forever until the courts knock it down through the concept of the Constitution of the United States, or until we get together with some common sense and vote these guys out of office.
Right, a right not stood up for is a right that's lost. And so you do have to right the politicians, and we do have to stand up and we fight against this, because when you don't, it just gets lost. And so here we go. Let's do it together. On Facebook, Sarah, when can we do a rent increase? Is it July 1st, 2021, or 12 months after that? So I guess.
Well, again, I think we talked about that. You are allowed to do a rent increase right now. The only exception would be for the city of Los Angeles, which has a moratorium, and unless there is a local municipality which has banned it under all state laws, you are allowed an immediate rent increase right this second.
Okay. On YouTube, Joe, do you have any idea how long it is taking to get a response after one's submitted an application? Not the money, but even just a response. Do you know anyone that's even gotten a response back yet?
I'm sure they have gotten responses. I just haven't heard that. I know that from the clients who I've talked to, that no one's received a dime yet. So,
Right.
but that money's sitting there, so hopefully it'll start to trickle down. And again, I'm going to encourage everybody, whether we think we can get it or not, or whether your tenant complies or not, definitely apply for that. If you can get 80% of your rent, you're going to be way ahead of the game than hoping that our judicial system is going to be there for you, because quite frankly, ladies and gentlemen, it's not. There's a failure of our government and our judicial system, even trying to get cases through the courts, though it's opening up a little bit better now. Even when the courts opened, trying to get paperwork pushed through that court system has been an absolute nightmare, where even the unlawful detainers, in the middle of lawsuits, the state have created new forms and made us now submit new forms and new declarations, which each court believes that they should be filled out, these forms, differently. So it's really been a nightmare, though it's getting better now. So we're actually seeing many of our cases that started a while ago now trickle down to where we're now actually getting lockouts from the sheriff's office.
Okay, on YouTube, Louis, can we start an eviction if they do not return? Well, we talked about that one. Let me go on to John. Okay, John, when would somebody that is quarantined at my place inland, not on the lease, need to leave by?
I'm not sure I understand the question. If they're quarantined because they have COVID or came in contact with somebody, if that person is not your tenant, he has no right to be in your property under any circumstance. So if you have a rental agreement which limits who can live there, to be frank with you, I don't care that he has COVID or not. He's invited, your tenant who did sign the rental agreement is allowing a stranger to live there. So you can bring forth an action right now. Now, And it's different if your tenant has COVID. That's a whole nother story, but you're not allowed to bring people in regardless of their health status.
All right. YB on YouTube. I had to sell my property because the tenant refused to pay her rent and I could no longer afford to hold on to the property. Can I take her to small claims court now, or do I have to wait until August 1st?
You would have to wait until August 1st. So the fact that you sold the property, it should be made aware that any rent owed to you for the time that you were the owner of the property is still owed to you. It's not owed to the new owner. So if you sold the property, for example, at the end of March, all rent owed to March is yours. You will, if the tenant signed that declaration, you have to wait till August. If the tenant didn't sign the declaration, you can bring forth that action now. If you're going to go to small claims court, you're limited to $10,000. Again, it's best to wait till August 1 if you're above that figure.
All right. So sorry to hear that, YB. That's horrible, and anyway, we'll stop there. SC on YouTube. What if the rental agreement is invalid, meaning missing key elements? Oh, invalid. They meant to put the word together.
It would depend what elements are missing.
Right.
I mean, generally, a rental agreement could actually be legal and be written on the back of a cocktail napkin as long as it states who the parties are, what the address of the property is, and what the rent is, and when it's supposed to be paid. It could be, basically one sentence, and that's considered a valid rental agreement. So I would have to know a little bit more specific as to what, quote, elements were missing.
Right. Give him a call. Corey on YouTube. Do any of these remedies apply to commercial property tenants? And what can commercial property landlords do?
Commercial property at this point in time is not covered by the Tenant Relief Act. So you have the right, unless there's a local municipality that's telling you can't, you can immediately bring forth an eviction with a 3-day notice for all the rent that's owed to you at this moment in time. Now, in the city of Los Angeles, there is a local moratorium to try to evict a commercial tenant who is in any way, shape, or form indicated that the reason why he hasn't paid the rent is due to the pandemic. If you're not in the city of Los Angeles, and I hate to be so local because I know this is going up and down the coast, but check with your local rules whether you can bring forth an eviction against a commercial tenant. There is no prohibition by any state law that prevents you from immediately bringing forth an eviction against that hair salon that was closed for all the rent that they owed you. Now, I'll tell you a little secret. If you're not in the city of Los Angeles, but you're located in LA County, Los Angeles County, if you have a tenant, a commercial tenant that hasn't paid you rent, you can immediately bring forth an unlawful detainer action by serving a 3-day notice. The county has a law that prohibits that, but they have a proviso. The proviso is that the tenant each and every month had to send you a letter in writing that stated that I have an inability to pay the rent because of the pandemic. And he had to do it within 7 days of each time rent was due. Well, I can tell you, ladies and gentlemen, no commercial tenant did that. So in LA County, we're bringing forth basically a ton of evictions based on 3-day notices. And when the tenants claim that they have protection under the County of Los Angeles's moratorium, which includes commercial tenancies, our position is, well, just show me that letter that you wrote every month to the landlord. And of course they can't, so they can't get the protection of the county statute. So again, it's incumbent on commercial landlords to check to see whether there's a local municipality which is prohibiting you from bringing forth an eviction right now. If there isn't, then by all means go forward with these commercial tenants.
Great, thank you. Ming Chen, if I get the rental assistance, can I still ask the tenants to move out or evict the tenants 60 days after the final month that the assistant payment covers?
Well, if you get the rental assistance, there's no prohibition from ending the tenancy, assuming you have the legal right to do so. So if you have the legal right to do so, you can certainly end the tenancy. Again, the tenant doesn't owe you any rent for that 1 year period coming from April of 2020 through March of 2021.
All right. Diane on YouTube. My tenant was filing COVID declarations from September through December in Los Angeles. She died in December owing rent, and she has no assets. Can I file for a state program if next of kin files the tenant portion on behalf of the tenant?
You can certainly try it, but I sincerely doubt whether it would be approved or not. I don't know that the statute has anything set up for that. So, but try it, and the executor or administrator of the estate will sign for the deceased tenant. But I certainly have my doubts.
All right. And on Facebook, Patty, I'm confused. Which is it? Can I start a legal action against a tenant on July 1st, or is it August 1st?
You can start a legal action. The tenant owes the money come July 1st, 2021. You can start a legal action, a civil lawsuit, as of August 1st, 2021.
All right. Wow, we have lots of questions. Okay. Sir Mac on YouTube. How do I know if my unit is subject to statewide rent control?
Well, your property is subject to statewide rent control if, number one, you're not subject to a local rent control ordinance. Number two, you're not subject to statewide rent control if your property was built within the last 15 years, or is a single family residence, or is a townhouse, or is a condominium. And the last one, and there might be another one, but the last one that I can think of is if you're in a duplex and it's the owner also occupies the duplex and the owner lived in the duplex prior to the initiation of that tenancy. That would be another exception. So basically, if you have an apartment house built more than 15 years ago and there's no local rent control like Beverly Hills or Palm Springs or San Francisco, then you're subject to statewide rent control. And make sure you give those forms out right now, ladies and gentlemen.
Great. Thank you, Dennis. And here's one from YouTube. Property Works Realty. Tenant given a 60-day notice to move because the owner decided to sell the property. Tenant did not move within the 60 days. We filed for an eviction and are awaiting. However, the tenant has paid some rent for the last few months, but nothing in the last 60 days. Can the landlord apply for the rent relief even though they are being evicted for a different reason?
That's a good question, and I'm not sure of the answer of that one. If you accept rent, the general law is if you accept rent past the expiration of the 60-day notice, then you're reestablishing the tenancy. So if you're going to get governmental assistance for that time period, I would think an argument could easily be made that you've just waived your notice. If you're going to apply for rent prior to the expiration of the 60-day notice, then I don't think that would affect or waive your 60-day notice to move in.
Okay, great. That's a good question. Okay, then we have Denise. How long does an eviction in LA City take?
It depends whether the tenant fights us or not. If they contest the proceedings, we're quoting anywhere from 4 to 10 weeks for an eviction to go forward. We've had some definite improvements in some of the courts, specifically in the Los Angeles court and in Santa Monica court. We've had some improvements in that. The outlying courts in other counties tend to be okay, but we've had some horror stories in other courts.
All right. Jonathan on YouTube. For those in LA rent control, what's the strategy to raise rent if the current rent is well below rental standards?
Well, if you're under Los Angeles rent control, the rent stabilization ordinance, then right now you can't raise rents at all. If you can somehow, some way have that tenant vacate the unit, then obviously you are free to raise the rent to market level, to any level, once that tenant vacates. So if you have the tenant who's violating a term of his contract, for example, he brought in extra people, he made an alteration to the premises, he brought in pets, something to that effect, then if we evict the tenant for those reasons, you would be able to raise rent to market level. You can't use, quote, the renovation that you can for statewide rent control. That doesn't exist in the city of Los Angeles. The other thing that you can do, which works really in any jurisdiction, is you can enter into what they call a voluntary vacate agreement. Some people call it a cash for keys, where you walk over to your tenant and basically you say, hey, I've got $10,000 if you move by the end of the month. That is a great strategy for raising rents. I myself, a few years ago, bought a building which had a tenant in there which was paying very low rent. And in the first week of owning the building, I said to the tenant, I'll pay you $10,000 if you vacate. And he quickly took me up on that offer, and I increased the rent $1,000. So it basically went from $1,000 to $2,000 for this unit, after, of course, a little bit of a fix-up. And if you do the math, you'll see that I recouped my investment within 10 months and increased the price of the building by over $100,000 just by that simple thing. So we do provide a service where we will prepare voluntary vacate agreements. They're a little tricky for example, in the city of Los Angeles, because there's certain things that you need to include in that and certain disclosure forms that need to go with it. But if anybody can encourage their tenant to move for a certain amount of money, that is a wonderful way to go.
Great. Here's Mark on YouTube. If the tenant is granted rental assistance either by the county or state program, does that count towards the 25% that they owe under SB 91? Or is their 25% have to come directly from them?
No, the 25% would be waived. If you're going to take governmental assistance, you're waiving 20% to get 80% for the period of, once again, through April 2020 through March of 2021. For months that are not included in that 1 year period, for example, April, May, and June of the year 2021, that the tenant would have to pay 25% if you served that 15-day notice and they returned the declaration.
Okay, great. On YouTube, we have Lana. Can we serve a 30-day notice to raise rent on July 1st? City of LA RSO property.
And the answer is no, because first of all, it's not over in the city of LA on July 1st. It's over when the king, Eric Garcetti, declares that it's over. If he declares it over in December, then it's over in December, and then you're not going to be able to raise rent for 1 year, which would mean December of the year 2022.
There's a good person to write a letter to. And on Facebook, MGC, my tenant didn't respond to the 15-day notice to pay rent, but they responded to the second notice. They requested a court day. We had a court day this Tuesday, and they didn't show up. The judge set the court date for August 16th for a settlement. I still couldn't talk to my lawyer. What does the judge need a settlement if this is a second time and they don't answer or show up?
Some of the rules of court in LA County require that there be a mandatory settlement conference. Judges are leaning over backwards to afford tenants any possibility that they won't be defaulted. So if there was a hearing, the judge could have immediately struck the answer of the tenant or allowed the case to go forward. In this case, the judge was following a rule of court, which of course he didn't have to since the tenant, the defendant, didn't show up. But they are requiring now for us to do a mandatory settlement conference. And then at the mandatory settlement conference, if in fact the case is not settled, then they set it for a trial date.
Alrighty, here we go. On Facebook, Raquel. Tenant is not paying since December 2019, 3 months plus before the pandemic. We went ahead and started the eviction process. She's still not paying and court date is being postponed now to July. She's working and she claims pandemic is the reason for her no rent payment. What does she do?
Well, this is where the judicial system is failing us.
Yeah.
They're pushing out cases way far in the future, and that's happened to us in some of our cases. Other courts are better than others, but this is a total failure on the part of our judicial system. We're entitled to a speedy trial date under the code. We're entitled to a trial date within 20 days. I don't know where that code section went, but it's been thrown out the window. And now this person who hasn't received rent for, what is that? It's 17. We're up to 18, 19 months for that person. And now she's looking at a trial date in July. It's really just been a failure of our judicial system in terms of protecting income property owners. You know, the reason why there's a court system was because man wanted to prevent his fellow man from going out into the street and dueling or shooting each other with weapons. So they came up with a court system which is supposed to do equity and is supposed to have a final resolution to the problem where two people, tell their side of the story, and then there's a trier of fact, either a judge or a jury, which is going to make a decision. But if you can't get justice, if you can't get to court, then what you have is anarchy. And that's what it is here. It's the governmental theft of income property owners.
And, it's creating a dependency on the government, too. And that's the bigger thing. And so you see it's shifting. There's a shift in the country where people are looking more and more to the government instead of looking to their own hands and standing up and doing something. And it's really something we need to speak out for because it's us today and what is it tomorrow, right?
And it's just going to keep going on and on. I liken it to a bank that is forced to keep its doors open with no security and a sign in front of the bank that says welcome. You know what? Even the most moral people on the planet are going to go in and take some souvenirs from this bank. And that's basically what this legislator have done with these rules, where anybody doesn't have to prove anything. You sign a declaration even though you know the person has assets, has money in the bank, never lost a job, continued to work, or never worked at all. It was just on a pension. The law is not set up for us to have any kind of a hearing to prove whether in fact that declaration was done under the penalty of perjury and whether he in fact committed a felony. So that's where we stand now, ladies and gentlemen, and this is what you get when you buy property in this state.
Right. So anyway, we'll stop. YouTube, Diana, what will protect me more from tenant problems, Airbnb or 1-year rental agreement?
Well, I don't know where your property is located. A lot of jurisdictions don't allow for Airbnb, and I think there's issues which come up with Airbnb, even though obviously the revenue is very good. So it's really just, quite frankly, a business model. I like, of course, being the old guy that I am, I like the traditional method of just renting to somebody who I've checked their sources, screened them well, of course, ran that credit check through the Apartment Owners Association, and I get a qualified tenant, and I have them sign that year's lease, so that I feel good about that the property is going to go to somebody who I believe to be responsible. Mm-hmm. On Airbnb, if these guys don't vacate, it is a type of an eviction. We've had people sitting in units that started out as an Airbnb for 6, 7, 8 months without paying, and it's dubious of what basis we can even evict them. So, but then again, there's people who make so much money on Airbnb and have it down to a T. So I don't want to step on that business model, but I think there is additional problems that you certainly have to be aware of.
Wow. All right. Now you just said a 12-month lease. Sometimes I've also heard you say do a shorter lease so that because that helps. Would you?
Shorter lease would only be for property that is otherwise subject to statewide rent control. If your property is subject to statewide rent control, you do not have to have a reason to evict within the first year. After the first year, then you need good cause to evict, like I want to move in to the unit, or the tenant is doing something wrong, like violating a term of his rental agreement. But during the first year, you can just serve a 30-day notice to vacate. Now, of course, you can't do that if you're on a 1-year lease. So I recommend for property that's under statewide rent control, do not use a 1-year lease. Do a lease that's 10 months, 6 months, or just give them a month-to-month tenancy. This way, if a tenant is going to be bad, but nothing over the top that you can just actually evict on, this way you don't need to have a reason for property subject to statewide rent control for the first year. So do a month-to-month. And then this way, if there is an issue, then you can easily do a termination notice.
And you better be a good tenant and take care of them or they'll leave, right?
There you go.
And that's a transactional. You do both of you reciprocal, right? Wouldn't that be nice? Zipporah, how do you sell your multifamily property with one unit, with one tenant, with one unit where there's a defaulting tenant?
Well, you can sell a property with a tenant in possession. Mm-hmm. Nothing prevents you, and that's what I'm always saying to the realtors that call up. Of course, the property is not going to show well, and maybe the tenant is not even going to allow any appraiser in or potential purchasers to come in to view it, so we have that problem. But it depends whether the property is under rent control or not. If it's a single-family residence, for example, and you'd be able to terminate right now, serve a 60-day notice, because assuming the law is over as of July 1st, that would be a proper notice to serve at this point in time, assuming the tenant is on a month-to-month tenancy.
Right, and that was actually, we had a seminar, we had a live stream, I think last week, and that was one of the questions that was asked, and one of our AOA brokers, they said, yeah, that happens, and they've seen that. And so, yeah, call AOA, we'll get you a free property valuation, and you can list it with us or get it sold with us without listing. We closed one the other day without listing even. Anyway, we were brokers before we were even an association. So a little history of AOA. And here we are on YouTube. Fiona, if tenants signed termination of lease and surrender agreement, can they be evicted if they refuse to move out?
And the answer is yes. That's certainly under the AB 1482. Signing an agreement to vacate and refusing to move is grounds for eviction. Right now, this moment, you'd have to also check to see if there's some local jurisdiction which is in control. For example, Los Angeles, if you sign a statement saying, I'm going to leave, even if you took money on a voluntary vacate agreement, that's not a ground to evict under the city. We have a way around it in our agreement, but as a general rule, you can't do that. But for most any other location other than the city of Los Angeles, you have the right to bring forth an eviction if the tenant agreed in writing that they were going to vacate on a certain date and then decided to change their mind.
All right, YouTube, Sylvia, is the city of Inglewood subject to statewide rent control?
And the answer is Inglewood has its own rent control, so you got to comply with that one. So the way it works is statewide rent control is non-existent if there's a local municipality that has its own rent control.
All right, Sandro on Facebook. If I plan to sell a property, it's a fourplex, do I have to pay moving costs to tenants if buyer wants the units empty?
You don't have to pay moving costs to tenant, but the tenant in general doesn't have to move. So you might need to negotiate that with the tenant where I'll pay your moving costs, I'll pay you relocation, but there's no requirement. But then again, you don't have any option to ask that tenant to move merely because the purchaser of the property says, as a condition of escrow, you have to give me a vacant fourplex. I mean, it's just silly. they might as well have a condition in the escrow that says, as a condition of this escrow, we expect you to move this building to Beverly Hills, because it's the same thing. You don't have the right to do that. So the fact that, well, it's in my escrow, I have to do it. Well, it might be in your escrow, but that doesn't mean you have the legal right to ask a tenant to move merely because you're selling the property.
Great. And Joe, is mail and post sufficient to serve eviction notices during COVID?
Yes, of course. But you first, under the law, and this comes under Code of Civil Procedure 1162, you have to first attempt to hand it to the tenant. If you cannot hand it to the tenant, then you are allowed to post one on the tenant's door and mail one by regular mail. Technically, you should be knocking on that door loudly, and if no one finally comes, then you can post one and mail one.
Great. And everybody, what we normally do at our $1 Million trade shows and at our AOA seminars is we have a line, and everybody gets to ask one question, and then they go back to the end of the line. And so if I'm skipping your questions, just know that we're trying to, there are way too many questions to get them all answered, and we're trying to just get at least one for some of you. And we won't be able to get all of them, but we're going to keep going here. So Flory on YouTube, doesn't LA County as well as LA City have a moratorium preventing no-fault evictions?
I'm sorry, could you repeat that question?
Doesn't LA County as well as LA City have a moratorium preventing no-fault evictions?
LA City certainly has a moratorium on preventing no-fault evictions. You cannot evict a tenant in the city of Los Angeles for no fault.
There we go. Uzo on Facebook. Is there statute of limitations to bring an unlawful detainer on an at-fault eviction it's a nuisance incident?
You can certainly bring forth an eviction where the tenant has created a nuisance. That's an at-fault eviction. That's just one eviction that's you can do in any jurisdiction. Again, we talked about the fact that you can bring forth an eviction where the tenant has violated a term of his rental agreement by having, for example, extra people, a dog, alterations to the premises. We had one case just recently where the tenant power was cut off, so he was literally running extension cords from his unit to one of the common area electrical plugs. And that certainly was an alteration of the premises, and we made a demand for him to stop, and now that case is going forward to trial.
Right, and so this question here, it's about, is there a statute of limitations, on that?
Well, there's no statute of limitations per se. I mean, obviously, if the tenant did something incorrectly like years ago, then certainly you can't bring that up now. It has to be on something relatively recent for an eviction to go forward.
All right. Debbie on Facebook, just to add, I have received 80% payment from the Tenant Relief Act. Okay. Debbie, you're the very first person that any of us know that has received money. So, wow, you are a blessed person. So there's Debbie on Facebook. Armin on YouTube. Does the City of LA 1984 apartment fall under state or city rent control?
Well, since the City of Los Angeles, you're not subject to the RSO for Los Angeles, Rent Stabilization Ordinance, if your property was built after 1978. So your property is not subject to LA rent control. However, it is subject to statewide rent control because it was built longer than 15 years ago. So you're limited in your rent increases to, once again, 5% plus what the CPI is, again, this year, though it's changing technically in May, to 0.7%. But again, if you did want to evict one of the tenants because the rent was low, you could do so on the basis that you're going to renovate the unit. And if by renovating the unit, you have to give that tenant relocation money equal to 1 month's rent. And then you're allowed, once that renovation is done, to raise the rent to market level.
Right, and I know like in Pasadena, or I believe in Pasadena, you need the permit before you can perform the eviction. Are
Yeah,
there
there are some municipalities that have some additional requirements. I know Long Beach does and Pasadena. But if you check with our office, we're happy to tell you exactly what's required for your area.
Great, and here we have Billy on Facebook. Can we raise rent immediately in Orange County for an apartment?
Well, if your property is subject to statewide rent control or not, you can do it immediately. The issue is how often can you do it and how much can you do it. If you're not subject to any rent control, you can raise it as much as you like, whenever you like. Obviously, you can't raise rent above market level. You'll never get someone to rent the unit. So it's really market level. But if you're subject in Orange County to statewide rent control, and again, the entire state of California, potentially your building would be subject to statewide rent control, you're entitled to one rent increase not to exceed 5% plus the CPI for your area.
Great. On Facebook, Kendall is asking, is there anything you would recommend for landlords to do other than wait for moratoriums to lift, like writing a councilman?
Oh, definitely. Definitely write your councilman and explain how this is financially affecting you and that this cannot go on and that this is a taking. And any elected official that you can think of, I would write to. I'd write letters to newspapers and see if you can get published and put the word out there. Do it on your Twitter account. Do it on your Facebook account. Let's get the word out there. I mean, I know the association has been doing that. I've been doing that and beating the drum on this for the longest of time. And eventually, ladies and gentlemen, somebody's going to listen to us.
Right. And even in the April magazine of the AOA magazine, you can just tear out the president's message pretty much and mail that. And anyway, you can do that. And also there's political action committee and a lot of this stuff. It just takes lawsuits and challenging and standing up against this stuff. So you can write a check out or you can get online and send a payment, or not a payment, but a donation to the AOA Political Action Committee. And so that will also help so we can fight the battle in the court. But then also we need to be prolific with our letters and send them often and to many people. So thank you for bringing that up, Kendall. I think that's really good. And a lot of us, we have good intentions, but like just got to make a point of doing it. So like say, okay, you know what? I've been saying I'm going to do that for a year now. Well, how about by the end of the day we have one done, we have a letter written or a check written or whatever. And so I do ask you to take action immediately, because it's easy to just let things sit on the side or on the back burner and not hit it. So here we are on Facebook. Daniel, my tenant has a boyfriend who is not on the lease. He uses drugs and has been destroying the apartment with a hammer. I did call the police but got no response. What should I do?
I would call my law office immediately,
exactly.
Because that's a violation of the rental agreement, that there's a stranger in there and also committing damage to the unit. So we would initiate a termination notice and then proceed forward with an eviction to evict everyone from the unit. And that case we can bring forth right now.
Right. All right. Thelma on YouTube. If a tenant is not content with a rent increase, can the landlord say, if you're not content, you can look for another place to live?
You can always tell a tenant that. I mean, unless the tenant's going to claim somehow that's a harassing statement. I don't believe that. But, I mean, the truth of the matter is, if a tenant is complaining about something legitimate that's not working in the unit, then you, Mr. and Mrs. Landlord, have an obligation to fix it. And, and not next week or the week after. You get on the phone, you get your plumber in there, or you get someone up there to fix the air conditioner, and you do it in a very short period of time. I never understood the motivation of landlords who own property and don't act responsible. That's what kind of, quite frankly, gives landlords a bad name to the media, even though they're more anecdotal stories than true. Most landlords obviously understand the rights and responsibilities that they have, and treat them accordingly. So if you have a tenant that legitimately needs something, then I would fix it. Now, this landlord was talking about that, hey, if you're not happy here, then why don't you just leave? Well, if in fact the tenant is talking about things out of the landlord's control or just superficial cosmetic items, then you know what? That's a fair thing to say. But the landlord does have an obligation to meet his responsibility dealing with the condition of the premises to make sure that it is habitable and that things are fixed in a reasonable period of time.
Great. All right, on YouTube, Tisben, how long are eviction cases taking to complete? And specifically what they mean is for the sheriff to come and remove the tenant.
We're quoting right now anywhere from 4 to 10 weeks. Again, there was a big slowdown period, but the courts have been getting better, and they're processing the paperwork. We have daily phone calls to court clerks to try to shake the tree a little bit in our office. And we have been getting cases. I mean, today alone, I think we have probably about 6 or 7 lockouts today with the sheriff's office.
Okay. Great. Barack, can an updated rental agreement be enforced if it has not been acknowledged or signed by the tenant, although a 30-day change of terms has been served on them?
Well, if you do a change of terms of tenancy and you attach a rental agreement and say, by the way, in 30 days, these terms of this rental agreement are now yours, you can actually do that. If you're not under any rent control, certainly you can do that. If you do that under rent control jurisdictions, most rent control jurisdictions say that while you can change the terms of a tenancy, you can't use that specific change to evict for. I know Los Angeles has that and many other municipalities. So you're not allowed to change the terms of a tenancy and then do an eviction based on that.
Okay, Roya on YouTube. Can I evict a paying long-term tenant for an SFR in Desert Hot Springs, Riverside County?
Absolutely. You're not under any rent control because it's a single-family residence. So serve a 60-day notice, and at the end of the 60-day period, if that tenant is there, we're happy to bring forth an eviction.
All right, and here's Phyllis on YouTube. I purchased the building and the tenant
Well, a tenant doesn't have to sign a lease. The tenant moved in, and obviously the then owner of the building didn't require it. So you can't force a tenant to do anything. You might be able to evict that tenant depending on what jurisdiction you're in and how long the tenant's been in possession. But if the tenant is a protected tenant under rent control, then you can't force that tenant to sign an agreement.
I don't get it. There we go. Working through this stuff. Here we go. Okay. Okay, for tenants who have not fallen behind on rent, do you recommend short or month-to-month rental agreements to avoid any possible rent? We did cover that, so let's go on. And Swan on YouTube, if I don't get back a signed declaration after the 15-day notice to pay rent or quit for 25%, can I start an unlawful detainer, understanding 25% rent can be paid at the end of June?
Absolutely. If the tenant, and we do a lot of these types of lawsuits, if the tenant was served with a 15-day notice, the tenant didn't pay the rent in full and didn't return the declaration, that tenant now is guilty of unlawfully detaining the premises, and an action can be brought.
Okay. Thelma, is the city of Bell or Bell Gardens subject to rent control?
The city of Bell does not have rent control. The city of Bell Gardens does not have rent control. However, as we stated, every single location in all of California can be subject to statewide rent control. So if you have a multi-unit building in the city of Bell that was built more than 15 years ago, you're subject to statewide rent control under AB 1482.
All right. In YouTube, do tenants that have been living in a rental property for 10 years or more have certain rights?
No right, more rights than any other tenant. The time period, 10 years, doesn't do anything. If you're under statewide rent control, you've been there less than 1 year, and you're on a month-to-month, then you don't need a reason to evict. After 1 year, you're a protected tenant. So the fact that it's 10 years doesn't add anything to it. There is one thing in the city of Los Angeles that says if you're a tenant and you've been in a property for 10 years or longer and you're in excess of 62 years of age, that you can't be evicted even if the owner wants to move in and pay relocation. That's an exemption in the city of Los Angeles. But other than that, 10 years doesn't add anything to the equation.
Now, what if someone signed up for the rental assistance program, and let's say they're the building's in the city of LA, but they signed up for the statewide one? What happens in that case?
Well, you can, I think the city of Los Angeles has their own program.
Yeah.
And of course, the state has their own program. I'm not sure that you're prohibited from applying to the state or applying to the city. You probably do need to apply to the city. I would certainly start with that one.
Right, and that deadline's tomorrow, correct?
Correct.
Okay, great. All right, Kevin on YouTube. A tenant almost set the building on fire by overloading washing machine. Is that cause for eviction? Properties in Long Beach.
If you overload a washing machine, that's going to create a fire. That's a good one. I guess because the drum where the clothes are were overloaded and, I don't know, caused a short in the motor. I'm trying to put my head around that one as to how that is. I'm not a mechanical guy. But the answer is absolutely not. At best, it's a negligent act, and it's probably for a washing machine to catch on fire because you overloaded it. That's not the tenant's problem. That's the manufacturer's problem.
Or user error. Right. Overload, right? So Lupe Fuentes on YouTube. Property is in the city of Paramount. Where do I check to see if the city has rent control?
All you have to do is listen to me. And the answer is Paramount does not have rent control, except, once again, that it could be subject to statewide rent control.
Right. Lauren K. on YouTube. A fair housing person said that if a tenant can take in another person, they can take in another person if they claim homelessness. Is that true?
Never heard that, and fair housing comes out with such erroneous information that it's shocking. That does not exist.
Okay.
So now we have to allow homeless people to move into our buildings. That's great. Where's that director for fair housing? I'd like to have a discussion with him.
All right. Blee Bruin on YouTube. For an existing tenant living in a single-family house, they moved in before AB 1482 passed. What happens if you don't serve an AB 1482 notice?
And we're getting some people, some attorneys representing tenants, and that's a really good question, that, for example, you're not under rent control, so you serve a rent increase for 10%. So then the tenant doesn't pay it, and you start an eviction, having nothing to do with COVID. The tenant's attorney could argue that your rent increase is illegal because if you don't serve the notice that the tenant is exempt from statewide rent control, then the way the statute is written is that means you are subject to statewide rent control. And if you are subject to statewide rent control, then you are not allowed to give a rent increase for 10%. It's only 5 plus the CPI. So you could technically lose your case on that basis. So it's really simple. If your property is not subject to rent control and you're leasing out that unit, make sure that exemption language is in your contract. If your tenant is already in possession, make sure you serve that notice to your tenant that it is exempt from rent control, so we don't get into that issue.
Right, and they are in Daly City in San Mateo County, and I do want to mention that we did a another live stream that was several weeks ago for Northern California. We know a lot of this applies to everybody across the state, but then all along the way, there's these local things that can supersede the state. So I would refer you to watching that video. And so if you're on the YouTube page for AOA USA, so it's YouTube, search AOA USA, and then there's home, and then there's videos. Click on the videos, and you'll see that there's a whole lot more videos than just what's on the home page, and then you can search there for that video, and call Allison up in our Alameda office, and she could tell you specifically which video that is, and hopefully that'll help you. Okay, Shoab, I'm in Bellflower. Can you deny a Section 8 applicant if you have a qualification criteria that requires a household income that is 3 times the rent, and the Section 8 cannot meet that criteria?
Well, you would have to include the subsidy that you're getting from Section 8, which means that the tenant would only have to make 3 times what his portion is. So I don't think you could deny an applicant on that basis. Right. But you can always deny an applicant that he has bad credit. So what the person is asking basically is they're talking about the fact that under a relatively new state law, we have to now we can't just dismiss Section 8 applicants. We have to fairly consider them, and so we have to go through their credit history. If their credit is bad, of course, we could deny them. And if we have a criteria of how much they have to earn, you're going to have to adjust that to how much the rent is that they're paying, and do they make 3 times the amount of the portion that they're paying?
All right, Joe Eggert. Are unpaid rents due to COVID exempted from contractual late fees?
They are exempted from contractual late fees. Quite frankly, if it's not rent, because it's a civil debt, then you can't charge a late fee, because a late fee is based on rent. Also, it begs the question by the use of the word late. It's a late fee. Well, if the government sanctions that your rent is not late, then you can't be charging your tenant a late fee because their rent's not late, because the government has sanctioned that they can pay that month rent 17 months after it was due.
All right, Ronald Wong. What options are available for a non-communicative tailgating tenant allowed in by a previous tenant? No lease has been signed.
Not sure I understand the question when you say tailgating tenant.
Yeah.
If he's creating disturbances like having parties, then that could be a nuisance. You'd have to get other tenants in the building to complain that this behavior is upsetting their use and enjoyment of the premises. Mm-hmm. So, but I mean, obviously, if he's a protected tenant, you can't just serve a notice to vacate. Even if he's on a month-to-month, you have to have a reason. Well, a reason could be this nuisance factor that he's having tailgate parties every week, and it's bothering the rest of the neighborhood.
All right. I think we're coming. There are so many questions.
We're almost there. Let's do a couple more, Jeff.
There are so many questions. You guys are awesome. You can call Dennis Block, and he can take care of you. If you're an AOA member, we'll be able to answer some questions for you as well. And anyway, yeah, so we'll just take a couple more. And really, Dennis, I'm very thankful for you. I don't know of a busier man than you. You get up super early, and you're at it from early in the morning. And anyway, so thank you for working so hard for everybody. Thank you for adding more people to your staff, and we know that you're doing everything you can. And so thank you for that, and for spending, you spent a couple hours here with us, so thank you.
Well, I got a cup of coffee, though. I appreciate that.
Yeah, that didn't really even cover the gas on your drive over here. But can we increase rent on earthquake retrofit that was completed?
Well, that's a good question. I know a lot of the municipalities, such as Los Angeles, allowed a pass-through for your retrofitting that they're forcing us to do. But if you got approved, but the mayor of Los Angeles had already put in a rent increase freeze, I don't think you can get it at that point. So you have to wait until our mayor, the king, declares that the emergency is over. And once he does, then that rent increase can kick in.
Yeah, and next week I think we do have a retrofit seminar, so you can tune into that one as well and maybe ask them that question. But I think that what Dennis is saying is right. And YouTube, Stephen, my tenant left my apartment in September 2020. Can I still apply for the rent relief to the city of LA?
I don't see any reason why you can't. The tenant owes the money whether he's there or he's not there, so I would definitely apply for it, and hopefully your tenant will also do his portion, but I don't think you're exempt because the tenant moved.
All right, on YouTube, Stephen, can I offer the tenant to move or vacate by giving him 1 month rent? The apartment's in North Hollywood. Can I offer the tenant to move or vacate by giving him 1 month rent?
You can offer the tenant anything. You can offer the tenant $1. You can offer the tenant a ticket to Disneyland. If the tenant accepts it and you have a firm such as mine prepare the correct documents for what we call a voluntary vacate agreement, then in that situation, the tenant is going to have to move.
Great. All right, here we go. We actually are getting to the end of the questions. I can't believe we're actually pretty close here. Okay. Andres on YouTube, for properties in the city of LA, if you have an eviction case and tenant requests a jury trial, are the courts currently seating juries, or are those delayed right now?
They have been delayed. However, the LA court, Los Angeles court, is now opening up, and we've been getting sent out for jury trials. So this is a common ploy by tenants' attorneys that they represent tenants who haven't paid rent or created disturbances in the building, and of course they're all asking for jury trials because they know these cases are going to get delayed and the cost to the landlords is going to escalate. So they all ask for jury trials now, and we're astute at obviously doing jury trials, forcing the issues to get to court, which is usually when they cave and settle, where they agree to have their clients move.
Okay, Phyllis, if I can't force a tenant to a lease agreement, how do I confirm who lives in the unit, and do they have to abide by the rules?
If the tenant doesn't have a rental agreement, then that tenant can bring in anybody who he wants because there's nothing to prohibit that. So the issue would be, do you have a way of terminating that tenancy? It would depend on whether it's under rent control or not, but it's a general rule. If you don't have a rental agreement, then I'm free as a tenant to bring in whoever I want. There's no limitation.
Okay, there's 2 more, and we're done. We're done with the first round, and I think that'll be a good
Can we go on for another 50?
Huh?
No, I'm just kidding.
I'm like, huh? I mean, we
I'm going to fall over here, but that's okay.
All right, John Chu. I am planning to build 2 ADUs above the carport. Do I have to compensate the tenants for the inconvenience?
So what you're going to do is you're going to build it above the carport, so obviously there'll be a point in time where the tenants are going to be inconvenienced that they're not going to be able to park their cars where they normally could. I would probably want to, just as a practical matter, offer the tenants some compensation for the time that they couldn't use those carports. I think that's just a fair way to play it.
All right, Linda Fang. Can I evict my tenant who has someone live with him which is not on the lease?
And finally and mercifully, the last answer to that question is that, of course, if they're violating the terms of the lease by having unauthorized persons there, then you certainly can bring forth an unlawful detainer, and we do that case all the time. I want to thank the AOA for allowing me to speak. Boy, did they run a great organization, not just this seminar, but all the seminars that they put on, and the service that they do to the community. I'm sure you guys are all members, and you know that you get your questions answered. And the free forms and the services that they do, not only in the real estate area, but also for credit checks and everything else. I know I sound like I'm a spokesperson for them, but quite frankly, they've been invaluable to me in terms of how I manage my own buildings, and also, of course, in the legal aspects. If anybody needs to talk to me, we don't charge for a phone call. Our phone number, it's on the screen there, but an easy way to remember that same number is 1-800-77-EVICT, EVICT. Or you can go to my website, which is evict123.com. Once again, Dan, Jeff, appreciate the opportunity of allowing me to talk.
Thank you so much, Dennis. And yeah, just to wrap this up, we do have another live stream at 1 o'clock. You've already been with us a while. And so yeah, if you want to check that out about 1031 exchanges. So go ahead and catch us back at 1, get something to eat. And next week as well, have a great schedule. Definitely sign up for that Pathway to Wealth and the one about preparing for small claims court. And just take a look and see if there's anything there that you want. It's on the AOAUSA.com website where you can see the different events that we have. And yeah, so just again, thank you, Dennis, for your kind words about the association. And we do, if you haven't joined or if it's been a while since you've upped it, go ahead and join AOA. And you'll see that not only did we update the website, we've added new services. We've even updated the membership program so that it is mobile friendly. So that's all there for you. Sign up, subscribe to the e-newsletter, and we'll see you next time. Thank you.